A complaint under the Nova Scotia Human Rights Act is a formal allegation that someone has experienced discrimination or harassment based on a protected characteristic such as race, religion, sexual orientation, sex, disability, or others outlined in the Act. In order for a complaint to be accepted under the Act, certain criteria must be met. Discrimination. The situation must involve discrimination as defined by Section 4 of the Act. Prohibited areas. The alleged discrimination must have occurred within one of the prohibited areas listed in the Act, such as employment, services, facilities, or accommodations. Protected characteristics. The discrimination must have been based on a protected characteristic under the Act. Some examples include race, sex, sexual orientation, religion, disability, etc. Connection between discrimination and protected characteristic. There must be a reasonable link between the protected characteristic and the alleged discriminatory act. Jurisdiction. The parties involved, complainant and respondent, must fall under the provincial jurisdiction of the Act. This means the parties must be in Nova Scotia or governed by provincial law. Timeliness. The last date of the alleged discrimination must have occurred within 12 months of filing the complaint. This is a strict time limitation, and if it is missed, the complaint may not be accepted unless the director and CEO grant an extension under exceptional circumstances. If you believe you have experienced discrimination or harassment under the Nova Scotian Human Rights Act, first step is to complete the inquiry form. This form asks you to explain the nature of the incident, when it occurred, and how it affected you. It's important to provide as much detail and clarity as possible. Once you have completed the inquiry form, submit it via email or, if necessary, request a paper copy through the Commission. If you need assistance, you can call the Commission. Here's a quick breakdown of how the complaint process works. After submitting your inquiry form, an HRO will review the information provided. They may reach out to you to clarify details or request additional documents. The HRO will determine if your inquiry meets the criteria for a formal complaint under the Human Rights Act. If the inquiry doesn't meet the assessment criteria, the HRO will explain why. If your inquiry meets the criteria, the HRO will assist you in drafting the official complaint form, which must be signed and submitted. At this point, you officially have a human rights complaint under the Act. Once your complaint is filed, it will be assessed for early resolution or moved to the investigation phase. This is a confidential process designed to help the parties involved have a respectful conversation and resolve the matter without the need for a formal investigation. Early resolution is facilitated by Commission staff using a trauma-informed approach, ensuring that all parties feel heard and respected. There is no fact-finding or blame in this process. The goal is to repair the harm and restore relationships. If a settlement is reached through the early resolution, a formal settlement agreement will be signed by both parties and must be approved by the Human Rights Commissioners. If no resolution is reached, or if one party declines to participate, the complaint proceeds to investigation. If early resolution doesn't lead to a resolution or isn't applicable, the complaint moves into the investigation stage. The HRO will act as a neutral party, gathering evidence and interviewing parties involved. This can include talking to witnesses and reviewing documents. After gathering sufficient information, the HRO makes a recommendation on whether the allegations represent a violation of the Nova Scotia Human Rights Act. The investigation report will be shared with both parties, and the HRO may recommend a course of action, which could include settlement or further legal action. If a settlement is proposed, a settlement agreement will be drawn up. The agreement must be approved by the Human Rights Commissioners. If the settlement is not achieved, or if either party refuses to participate in the early resolution, the investigation continues. At any point in the investigation, the HRO may facilitate a resolution conference, which is a restorative process where both parties discuss the issue directly, with the goal of repairing harm and finding a resolution. This conference is voluntary. If the investigation concludes that there is insufficient evidence to support the complaint, it may be dismissed. Both parties will receive a letter explaining the HRO's decision. If the complaint is dismissed, the complainant has 15 business days to respond with additional information. The director and CEO of the commission will review the decision and either uphold it or ask for further investigation. If the director and CEO uphold the dismissal, the complainant can appeal the decision by requesting a judicial review from the Nova Scotia Supreme Court. If your complaint involves discrimination that occurred more than 12 months ago, it cannot be accepted unless exceptional circumstances apply. In such cases, you must apply to the director and CEO for an extension of up to 12 additional months, explaining the reason for the delay. The process ensures fairness and neutrality. The HRO is there to investigate and facilitate, but does not represent either party. By following this process, you are taking steps to ensure that your human rights are respected and protected under the law. The Nova Scotia Human Rights Act upholds the principle that everyone, regardless of their background, is entitled to the rights without discrimination.